is CGTN, China Global Television Network.
Years of a maritime border dispute between Kenya and Somalia culminated in a ruling this October by the International Court of Justice at The Hague. The 100 square kilometer patch of ocean in question is believed to be rich in offshore oil and gas, which both countries claim sovereign rights to for exploration and economic gain. The case between Kenya and Somalia has put a renewed spotlight on the delimitation of maritime boundaries in Africa. And now questions are abound on whether a grey area exists in the definition of international maritime boundaries. The ICJ's ruling mostly gave Somalia control of the contested area. However, Nairobi has rejected the court's judgment. So now, what are the ramifications of the ICJ's ruling? And with no means of enforcement, what happens next? I'm Beatrice Marshall. Welcome to Talk Africa. Let's briefly look back at the sequence of events leading up to the determination this October. In 2009, Kenya and Somalia reached a UN-backed memorandum of understanding to resolve their dispute through negotiations. 4 years later, in 2012, Kenya is reported to have awarded exploration rights to foreign oil companies, a move that Mogadishu termed as illegal. Somalia then moved to the UN's highest court in 2014, seeking a determination on who held exploration rights for oil and gas in the region off East Africa's coastline. In 2019, tensions escalated between the neighboring countries, with Kenya also accusing Somalia of starting the process to auction off oil and gas blocks in the disputed zone. The 15-judge bench delivered its determination on the case this year, splitting the maritime zone into two, with Somalia getting the larger share. It rejected Kenya's claim of an existing agreement on where the borderline stood, while also rejecting Somalia's claim for reparations from Kenya. Well, let's now bring on board our panel of experts to help us further understand this rather intriguing dispute between neighbors Somalia and Kenya. Joining us via Zoom from Accra, Ghana, Kamal Din Ali, the Executive Director for the Center for Maritime Law and Security. In London, United Kingdom, is Dr. Nkeru Skocha, a jurist and research fellow in ocean governance and the law of the sea at the University of Gothenburg. And joining us from Johannesburg, South Africa, Timothy Walker, the maritime project leader and senior researcher at the Institute for Security Studies. Thank you all for being here with us and joining in this discussion. Dr. Skocha, if I may start off with you, this has been a rather long-standing dispute between Kenya and Somalia that was ruled on by the International Court of Justice in The Hague around October the 12th. Let's first take a look at the submissions by both parties, both sides. What was Kenya's argument and what was Somalia's argument?
Firstly, Beatrice, thank you for inviting me. This case really boils down to two issues. Firstly, was there already an agreement in place between Somalia and Kenya? And two, what method would they employ in dividing that contentious area? And so Somalia was the applicant in this case, and Somalia applied to the court, asking for the court to divide the boundaries using a method called equidistance method or median line. Kenya, on the other hand, said that there was already an agreement in place, and if the courts were to find that there wasn't, that the court should employ another method, which is called the parallels of latitude method, which follows the latitudinal line that goes horizontally across the Earth. And so this is what the court had to look at. So firstly, examining where there was an agreement, the court said there wasn't. And then in terms of the method to be used, the court applied a mixture of equidistance, median line, with adjustments in favor of Kenya.
Kamal, what's your take on the dispute and the judgment?
To follow up on where inquiry left, there were two divergent positions from Kenya and Somalia. And to add up to the Kenya's part of the argument, Kenya argued that there is already an agreement. If there wasn't an agreement, there is a tacit agreement based on acquiescence. For that matter, Kenya was evoking a rule of international law that says that apart from formal or written agreement, there can be a tacit agreement based on the conduct of a party. And thirdly, Kenya then argued that in the event that if the court will not make a submission on behalf of Kenya or satisfactory to Kenya based on any of these two grounds, then the parallel of latitudes, which is a method advanced by Kenya and which is one of the methods of delimitation, will be a fair means of delimiting the maritime boundary, in this case, between the two countries.
Timothy, I want to go back to the history of this dispute, because to understand why exactly this has raised temperatures in The Hague between the two countries, what is the history of this maritime border, and why has delimitation only become prominent in the last decade or so, given that the demarcation of many African borders, particularly land borders, goes back to around 1885?
Yeah, one of the major things we're discussing when it comes to boundary disputes on land and at sea is the potential that lies within that zone or area which is being disputed, or a new kind of arrangement being created. For a large part in terms of the economic resources which are located within there. With the sea boundaries, the way we often look at it is it gives you kind of the title deed to either exploit or to extract or to give the concession or the license to somebody else to do so. So there's a lot of revenue to be gained from having the legal deed or undisputed access to these resources. What we've increasingly noticed in the context of this particular debate, but also maritime debates around the world and land ones as well, Africa and around the world, is that this is becoming very wrapped up in the language and rhetoric of sovereignty. So as soon as it becomes perceived as a matter of disputing sovereignty, of potentially losing territory, it becomes a very hot political topic, which is sometimes open to abuse in terms of how it can be framed. The way that the law of the sea and all the supporting conventions and instruments determine sovereignty, jurisdiction at sea, it differs a bit from land. There is a distinction to be made there. And because land issues have tended to take priority over the last, mentioned for a couple of decades, the maritime ones have not really come to the fore until now, when there's a huge interest which has come about through trying to develop the resources located in ocean areas.
So if you look at what the two countries want, Dr. Scotcher, Somalia wants the maritime border to run diagonally as an extension of its land boundary, while Kenya, on the other hand, wants it to run parallel to the latitude eastwards and towards the border town of Kiyunga. Now, one is prone to ask, why wasn't there a clear-cut boundary at the beginning? Is there a gray area in how maritime borders are therefore defined?
There isn't a clear area. What the court is usually guided by is one goal, and the goal is that of achieving an equitable result. Now, the geographical issues and the geographical situation, it's not for the court to refashion nature. What the court does is to look at the circumstances and look at what is on the ground, and then make a ruling as to what is best for the party. Incidentally, if you look at the contested area and the final judgment, it actually goes into Kenya's favor in terms of ratio. So Kenya gets 1.3 as opposed to Somalia, which is 1. The ratio of that contested area actually goes towards Kenya's favor. So There's no gray area. What there is a balancing act of trying to have some predictability with the law, but be flexible as to the geographical situations of the parties.
Timothy, coming back to you on exactly about this ruling, though, because I want to find out from you if this ruling is followed, because both countries were arguing, you know, Somalia wanted the border to run diagonally as an extension of its land boundary, while Kenya wanted to run parallel to the latitude. If the ruling is by the ICJ is followed, what will be the implication, though, in reshaping the maritime borders around the East African coast? Does it have much impact?
It could have an impact, certainly, because it does seem that Kenya's boundaries, or the boundaries that it claimed to have projecting, as both previous speakers have said, parallel out to sea, are rather unique. They don't really correspond to the way the boundaries have been drawn elsewhere. So you look at the boundary to the south between Kenya and Tanzania as it projects out to sea. It also runs in a parallel state, and it doesn't seem that that boundary will maybe come up for a discussion or a dispute in the future. It's not like the disputation between Kenya and Somalia. But there are other parts of the East African coastline, in particular in the Mozambique Channel, where a number of islands are disputed between France and Madagascar, France and the Comoros, and France and Mauritius. And so even if the effect of changing this particular line at sea, even if that particular line doesn't have an impact as such, the fact that disputes are likely to occur more and more with other countries or between other countries in the region means that they also need to look at what is the most feasible, effective means of determining that boundary. The ICJ, and I completely agree with what Kuru was saying about the three-step methodology which is applied by the ICJ. This is honed over decades of countries complying and seeking this kind of way of addressing as well. So there are a couple of lessons to learn. It depends on whether countries are willing to, right, in a sense, take it to the ICJ in the future, or whether they'd look for alternative means of determining their boundaries through some kind of diplomatic process, which we have heard Kenya say that they are willing to sort of enter into for a discussion on this. But in a sense, it would be good to see that all the countries where they might have boundary concerns, either existing or potential in the future, escalate this up their priority list and look for what would be the best way of doing it, rather than take it to a court or a process which there is no appeal, there is no way of getting around that, in a sense. There are lots of what I'm trying to say is there are lots of ways of determining all sorts of boundaries before you get to the ICJ. We'll
look at those alternative means in a moment, Timothy. But Kamal, I want to get your view on this, because there have been similar cases of maritime border disputes in the west coast of Africa. And I recall in mind between Ghana and Cote d'Ivoire, between Nigeria and Cameroon about the Bakassi Peninsula. Did it have much impact on the outlook of the maritime borders there?
Yes, exactly so. We are dealing much also in the context of West Africa, where a good number of maritime boundaries remain undelimited, which means that they haven't been determined by the states. And as you rightly said, in the last couple of years, there was a Ghana Cote d'Ivoire maritime boundary dispute. And then before then, a decade or so ago, there was that of Nigeria, Cameroon. In both cases, of course, the court followed the equidistance principle and the three-step methodology. Indeed, in the case between Cameroon and Nigeria, Nigeria did advance quite a number of arguments, but ultimately the court went back to the methodology. And in that case, a single maritime boundary was drawn from the territorial sea through the exclusive economic zone to the continental shelf. And in the case of Ghana, Cote d'Ivoire, again, Ghana advanced as many as 5 arguments in support of this case. The court did dismissed four of the arguments, including, interestingly, the same tacit agreement that Kenya advanced here in the case of Somalia, because the court have insisted that to have a maritime boundary determined on the basis of tacit agreement, a very high level of evidence is required, and that evidence must be definite and it must be irrebuttable. And in almost all these cases, it is indeed very difficult to have that kind of irrebuttable evidence. So the same jurisprudence that the court relied on in the West African cases that you mentioned, right, even as far as the case between Senegal and Guinea-Bissau many years ago, is a methodology that has developed and matured and found pronouncement in the Kenya-Somalia case.
So we're hearing, though, Kamal, that, both Kenya and Somalia are pretty much sticking to their guns when it comes to how the court ruled and what they wanted out of it. In those cases that you mentioned in West Africa, how did it pan out politically as well as economically? Because there was an issue of a resource dispute there as well.
Yeah, importantly so, I think, and as Tim has indicated, states have all these options, and most of those options do exist before a determination is made. And after a determination is made, the options are much restricted, but there are still options that are available to the states, because states can always determine what they want ultimately. In the cases that you mentioned, in the Ghana-Cote d'Ivoire case, the two countries came then to sit down and ultimately agreed to physically have a translation of the judgment into a maritime boundary. And it took much a longer time in the case of Cameroon and Nigeria, including various interventions by the United Nations, setting up commissions, before ultimately we seem to have had what we called a solution in the case of Kenya. But it is also interesting to take, for example, an example as in the case of Nigeria and Equatorial Guinea, or Nigeria and Sao Tome, where in order to prevent such a dispute coming up, the two countries came up with a joint development zone, and that has actually fostered relationship between Nigeria and Equatorial Guinea and Nigeria and Sao Tome and Principe, and they never had to go to court, learning from especially the Bakassi case.
Well, on that note, we're going to take a short break, but do stay tuned. Talk Africa continues in a moment.
Each day, there are millions of stories. Each one can open new perspectives, new possibilities. Wherever you look, we are there to see, discover, explore. We put the pieces together to find what really matters to you, all around the world, all around the clock. Our reporters are at home across the globe. From our headquarters in Beijing and production centers in Washington, Nairobi, and London, China Global Television Network. Stories from across the globe, reaching people across the globe. CGTN. See the difference.
Welcome back to Talk Africa. Our panelists standing by, Dr. Nkeru Scotcher in London, Kamal Dean Ali in Accra, and Timothy Walker in Johannesburg. And let's continue with this discussion. Dr. Scotcher, if I may return to you for the moment. So talk to us a bit more about this delicate balancing act that has to be done, because what are the sort of fundamentals that govern, the law of the sea and the possible challenges to its enforcement?
Right. This is quite an interesting one, because the law of the sea as a whole is all about balancing interests of states, their sovereign rights and their interests, in addition to common interests. And when it comes to dispute, what the court is trying to do is to find, in some ways, a middle ground, and a way that has established methodologies throughout time. So the process of dividing boundaries has been going on since coastal states existed. And method has been in place since the 1945 and 1949 North Sea continental shelf case, which incidentally, you'd find Germany in a similar situation to Kenya. But what the court tries to do here is to say time and time again, equity doesn't mean equality. And if you look at the coastline of Somalia and contrast it with Kenya, Somalia has quite a substantial coastline. And so what the court is doing is trying to find a way in between those claims and in such a way as to be equitable to both parties, bearing in mind that it cannot refashion nature. And so that's the challenge, and one that is ever evolving, and one that is constantly being re-examined and reinterpreted by the court, especially in relation to African states.
Kamal, let me come to you, because we do understand that the judgment is binding for the parties concerned. Even if the court does not have the means to enforce this, what happens to enforceability, though, if the parties continue to disagree?
Once you are a member of the United Nations, and under Article 94(1), I think so, of the United Nations Charter, you undertake to abide by the judgment of the ICJ. So in that regard, one would expect that Kenya will actually abide by the judgment of the ICJ. But as Tim has also indicated, and Kiri also indicated, the states can find other means of enforcing this judgment, or let me say, taking this judgment up and moving upon it and find solution to it. But ultimately, if we were looking for the most enforceable mechanism within international law, then the Security Council under 95.2 and the 94.2, I believe, of the UN Charter has the power to compel a state to implement the judgment of the ICJ. So what I'm saying here is that Kenya has an obligation to accept the judgment. The two states can find other means of enforcing the judgment, but ultimately, assuming that there is a need for Kenya to be compelled, then it is within the remit of the Security Council to compel Kenya to accept the judgment. Of course, we do know that the way diplomacy works, the Security Council will not just ask Kenya to enforce it that way. They may adopt a resolution urging the two countries to find a final solution and urge Kenya to abide by it. So this is how international diplomacy will work in practice. Otherwise, there is that compelling authority by the Security Council to do so.
All right. So, Dr. Scotcher, you've previously talked about the need for certainty and flexibility in delimitation of maritime boundaries. Tell us more about this.
Well, if you think about the Africa as a whole, and you think about the plans in the future to have an African maritime strategy document talking about a combined maritime zone, African states need to have in place actually defined boundaries, because then with that comes title and the right to be able to license the resources in this zone. And so this is one that is important to African states, and one that African states have championed from the very start of the Law of the Sea process. It's incidental that this is Kenya taking this position, because Kenya was very much, the leader and the champion for Africa and the African group, their delegates, during the Law of the Sea negotiations and leading up to the treaty. And so it's one that African states need to take seriously in terms of making sure that their boundaries are defined as African states move forward to establishing a combined maritime strategy and combined economic zones.
So I want to get your final comments here, and looking at where the two countries are at the moment. Kamal, and I start off with you. Where do the two countries go from here?
I think it is important that even in the face of the ICJ judgment, that the two countries know that the relationship between them is much more important. it is expected that Kenya, as a good member of the international community, will, after the initial statement that has been issued, rethink through and look at the judgment. And then there should be a way that the two countries should use diplomatic means to either strictly enforce the judgment as was pronounced by the ICJ, and that is in many ways a legally right judgment, and it can be or should be enforced by the two countries, or they can find other means of coming to a solution. But looking at the fact that they've traveled this far, I think that ultimately it is the ICJ judgment of 12 October that has to be enforced. And they should look at it that way and build relationship across the bridge and deepen their relationship in many other areas, because that is ultimately important.
Dr. Scotcher, your thoughts on where the two countries go from here?
I would recommend that they get back to the drawing board and they start a meeting, start to discuss and start to get together, perhaps set up a joint commission where they can look towards implementing the judgment, perhaps look to avenues where they can agree. You know, there are instances where there have been judgments and states have decided to agree and follow another line. So it's all down to the sovereignty of states is paramount. And so what the International Court of Justice is doing is just working within these confines. And so it's really down to the states to come together and agree as to the dividing line.
Timothy, your thoughts? Where do the two countries go from here?
I think this is a great opportunity to think of what's going to happen in 2022. We've got a couple of UN conferences coming up on oceans and the law of the sea, and Kenya is actually a champion. It's hosted Blue Economy conferences in the past. It's hosting, I think, with Portugal, this event in Lisbon in 2022. So I think it would set a fantastic image for Kenya to take the lead and to consider maybe discussing with Somalia in particular on this basis, but also pointing out to countries that we shouldn't just, leapfrog over solutions. We should try and exhaust all kind of diplomatic solutions first. So if there is some kind of conference, a bilateral conference, and that would be fantastic. These things are obviously much better solved through diplomatic means than any other means. So I really think, I imagine as well, there'll be actually a fair amount of, if not pressure, then perhaps some encouragement from the international community for the two states to start undertaking these kind of discussions and to not allow them other political issues to be linked. We've seen ambassadors expelled in the past. We've seen visas being denied to citizens of each country. We don't want to go down that route if this dispute starts playing out in these other arenas. Keeping it to this and honoring that kind of, like say, that diplomatic avenue is crucial.
All right. Thank you very much for your thoughts, and we'll leave it there on Talk Africa this week. Thank you to our panelists for their insightful contributions to this discussion. In Accra, Ghana, Kamal Dean Ali, the Executive Director for the Center for Maritime Law and Security, Africa. In London, United Kingdom, is Dr. Nkeiru Scotcher, a jurist and research fellow in ocean governance and the law of the sea at the University of Gothenburg. And in Johannesburg, Timothy Walker, the Maritime Project Leader and Senior Researcher at the Institute for Security Studies. Well, you can engage with us on this topic and more through our social media platforms on Twitter and Facebook, and also catch this and more episodes of Talk Africa on our YouTube playlist. See you again next time on Talk Africa. I'm Beatrice Marshall. Bye-bye.